Another one of these Latin canons that we'll look at is expressio or inclusio unius est exclusio alterius. The expression or inclusion of one thing indicates the exclusion of the other thing, of another thing. Or another way of saying this, when there's particular things enumerated, things that are not enumerated are not intended to be included or covered by the statute. Again, of course, whether or how this might apply depends quite a bit on context. So here's an example. A statute that says any horse, sheep, or cow must be registered with the Commerce Department. So would this include turkeys? Well, you might say it could, and if I apply some of the like nocitura sociis type canons, maybe it does. On the other hand, if I apply this expressio canon, I might say, well, look, this statute very specifically registers or lists certain kinds of animals. And if there's going to be a kind of, the background, of course, is we think there ought to be, sort of free trade and free commerce. And if there is going to be some kind of restriction that requires a registration or a tax or whatever it might be, then those things we would want to be specifically and expect to be specifically enumerated in the statute. So if the legislature wants to include turkeys, they can list them and include them. But since they didn't, then turkeys aren't included in the list. So you can see how that expressio canon might apply, but also how it sort of plays off against the other associational canons. Here's another example of expressio. It's unlawful to to hit, slap, or kick your sister. Does this mean you're allowed to pinch your sister or bite your sister? Well, again, you might say, well, expressio, right? It's not listed, and if the legislature wanted to include that, they could include it. On the other hand, it would be very fair to say, well, yeah, but maybe this is a circumstance in which the legislature is specifying a range of kind of harmful conduct that's akin to battery. And maybe then we'd apply one of the associational canons and say, pinching and biting is kind of like slapping, kicking, or hitting because it often happens in the course of an altercation or a fight. You could really work that out either way, depending on which approach you're taking, your philosophy, and which canon you're applying. So now let's talk a little bit about the grammar canons. And these can be a little bit counterintuitive because, especially after you've gone through your first year lawyering class, the importance as a legal writer of good grammar and being succinct and using proper punctuation and those sorts of things. And if you're drafting a statute, of course, you ought to try to achieve, to seek the same goal. But the canons of statutory interpretation provide a fair amount of leeway when it comes to grammar. So, for example, punctuation. Well, the background of the English rule is that punctuation forms no part of the statute at all. Why is that? Well, historically, when Parliament passed a statute, the actual statute was what Parliament spoke or passed, and then a clerk is transcribing and enrolling the statute later on in the official record. So the original thing as kind of transcribed before the clerk formally enrolls it didn't have punctuation. So the English rule, punctuation is no part. Now the modern rule really is punctuation is used as an aid in statutory construction, perhaps even as a last-ditch aid in statutory construction. But punctuation is not necessarily absolute. So here's an example. Let's say a statute that requires, that states that pay for street cleaners shall not exceed the following. Of the section foremen, $1,000 each, semicolon. Of the hostelers, $720 each, and extra pay for work on Sundays. $120 each, comma, and extra pay for work on Sundays. You can see this is a bit of an older example. Are the foremen entitled to extra pay for Sunday work? Well, there's a case interpreting this statute that is just an illustration of using grammar as an aid that says, no, this semicolon separates the group of foremen from the group of hostelers. The comma with the clause about extra pay on Sunday is after the semicolon and applies only to hostelers. Just an example of a way that you could use grammar to help clarify a statute. So another one of the grammar canons is the rule about conjunctive versus disjunctive connectors. Conjunctive, of course, is and disjunctive is or. And here again, the general rule will be, a term that's connected by or, often read to have separate meaning and significance, and we saw Justice Thomas, right, apply that in one of the cases we just looked at. There are circumstances, however, in which or can mean and or. So take this phrase, I want this or that. So let's say, deliver me apples or cheese. And let's say that you bring to me both apples and cheese. Have you contravened my command or my request when I said deliver apples or cheese? No. Yeah, you delivered them both. You've satisfied it. You could have delivered just apples. You could have delivered just cheese. But or can be satisfied through and or. There are also cases in which or and could be used interchangeably. So think about this example. The following three foods can satisfy the requirement of this statute: apples, pears, and cheese. Well, does that mean that you have to deliver apples, pears, and cheese all together to satisfy the statute? Or does it mean that you can deliver any one of those three, in which case really the and functions as an or? So you just have to be careful of the context. Now maybe that's not the best drafting, maybe it should say or there, but that's a possibility. Another thing to keep in mind here is De Morgan's laws, which are laws about how mathematical statements and concepts are related through their opposites. It's really a set of ways of thinking through mathematical set theory, which I frankly know really very little about, but I just know about it because of De Morgan's rules as they apply in statutes. So here's how this works. Not A and B can mean either not A or not B. See how this is a variation on the sort of apples, pears, and cheese thing that I mentioned before. Not A or B means not A and not B. So if you think about it for a moment logically, you can see why that applies in the way it does. And so you have to be careful if you see a statute that might be written in a form like this. So here's an example. It's an affirmative defense that real property cannot be seized. So this is an affirmative defense to the government seizure of property in connection with a drug crime, which there are many statutes that allow the government to do that, right? So an affirmative defense, real property cannot be seized if the drug crime was committed without, notice that negative, without the knowledge or consent of the owner. So this is a place in which De Morgan's rules might well apply, because you've got a negative and then an or, right? So if we apply De Morgan's rules in this case, we would say it means knowledge and consent. Now, just to confuse things a little bit more, in this particular example, the Second Circuit decided this case and said it's a defense if there's a lack of consent alone, but only if the defendant took reasonable steps to prevent the illicit use once he knew of it. What's the Second Circuit doing there? Why is it ignoring De Morgan's rules? Well, De Morgan's rules are rules of mathematical set theory. They're not absolute rules of statutory construction. They can be an aid to statutory construction, but if you have a purposivist court, like I think the Second Circuit was in that case, you might find a way of reading the statute a little bit differently to make it come out in a way, the court might do that to make it come out in a way that it thinks is more fair. And whether that's appropriate or not, of course, depends on what you think about your philosophy of reading statutes. Another grammar canon is the uses of the words may or shall, mandatory language versus discretionary language. So the word shall often excludes discretion to account for equitable or policy factors. It's a mandatory thing. But, as you might guess by now, may and shall are sometimes considered interchangeable. A lot of this is going to depend on the context of the statute, on the background, on the court's philosophy, and so on. I think you're starting to see a little bit of a pattern in how these canons get applied by different courts. Single and plural numbers Now here, you're actually going to look at, in the federal context, you'll actually look at 1 U.S.C. Section 1. Section 1 of Title I of the U.S. Code is called the Dictionary Act, and there are a number of specific principles and definitions stated there. So if you do have a federal issue involving statutory interpretation, you want to take a peek at the Dictionary Act and some other parts of Title I, which have specific definitions. They may or may not apply to your circumstance. And you want to keep the same thing in mind in a state context as well, because many state codes also have dictionary provisions. And this is a general dictionary provision. Of course, specific statutes very often have specific definitions of terms that apply to that aspect of the code. So the Dictionary Act says that in determining the meaning of an act of Congress, words that import the singular include and apply to several persons, parties, or things. Words importing the plural include also the single. No human beings may jump the fence. Human beings is a plural. Well, if a single human being jumps the fence, according to the Dictionary Act, that's still covered. No human being may jump the fence. That's phrased in the singular. Well, again, under the Dictionary Act, that means if it's 5 human beings altogether jumping the fence, they're still each culpable, right? So you can see why that rule is there and how it works. As I mentioned, there are other parts of Title I that have specific definitions. So you'll want to look through sections 2 to 8 of Title I, and you'll see some specific definitions and why they're there and what they relate to. Male and female pronouns. This is another one that's covered in the Dictionary Act, and this one might be less sort of counterintuitive or surprising to you, but the male includes the female, and female includes the male. So no man may jump the fence. Generally, under the Dictionary Act, that's going to mean no man or woman can jump the fence. Now, again, look at context. Maybe there's a reason why it applies only to men. You have to understand the context, but then also take the Dictionary Act. The golden rule against absurdity is a rule that says interpreters should adhere to the ordinary meaning and grammatical construction unless that leads to a manifest absurdity or repugnance basically to public policy. And so it would allow for a variation or a modification to avoid that absurdity or repugnance. Now you might gather that this kind of statute, this rule against absurdity, is more likely to be applied by a purposivist than a textualist, although there are times when you might see a textualist invoking this. A textualist is more likely to say, well, if the result is really absurd, then there's a problem with the way the statute is drafted and it has to go back to Congress, or Congress should fix that absurdity or that seemingly incorrect policy result. Whereas if you're more on the purposivist side of things, you might invoke this canon and say, no, I'm just generally going to presume that Congress doesn't intend any absurd result. This canon is also related to one that we've briefly seen before, which is the idea of scrivener's error. So an obvious mistake in the transcription or the writing down of a statute can be corrected. As we mentioned in class when we first talked about this, let's say that the context of the statute is really clear that the penalty for something is $1 million, and the decimal point gets misplaced and it says $10. That's a more obvious kind of scrivener's error in many cases that's easy to fix, but there are times when it's a little bit harder to discern, is this really a scrivener's error? Sometimes, as we've already seen, courts will apply the rule against absurdity and invoke the idea of a scrivener's error and really read the statute in a way that they think makes more sense as a matter of policy, whereas, again, a textualist is less likely to do that unless the scrivener's error really clearly is something like a misplaced comma or a misplaced period.